San Antonio attorney Alan Tysinger here. What is an extent of injury dispute in a Texas workers' compensation claim? Well, what we call an extent of injury dispute is when the insurance carrier says, yes, we agree that you were injured on the job. We agree that we are liable to pay you money and medical care. We believe that you are hurt and that you should be taken care of. But we don't think that everything you say is hurt is actually hurt, at least not from this injury. So the insurance carriers will very commonly in Texas receive a report of injury from a person, and that report of injury says that they fell off the back of a trailer and they sustained an injury to the elbow. Well, very commonly the insurance carrier will say, well, we agree that you fell and hurt your elbow, but it was just a contusion. We don't think when your doctor did the MRI that it showed a tear in your elbow, that was actually caused by the fall. So they may accept a sprain or a contusion diagnosis, but deny or dispute a tear diagnosis to a tendon or ligament in the affected body part. You see the same thing happen with an injury to the back, let's say the spine. Someone is lifting a heavy object and sustains an injury to the back, or they're involved in a motor vehicle accident and they injure their neck, a whiplash injury. The insurance company may say, yes, you sprained or you strained your back, so we accept a strain diagnosis. But the MRI is showing that you have a bulging disc or a herniated disc in your back. That is not something that's from the accident. We believe that is degenerative in nature or pre-existing in nature, and we are not going to cover it. We're not going to cover your lost time from work. We are not going to cover injections. We are not going to cover the surgery that your doctor says that they need. And that really gets to the heart of why these disputes come up, is because expensive medical care and expensive lost time from work are usually what prompt these disputes over the extent of the injury. There's another kind of extent of injury, and that is when there is a different body part involved. So example would be that you fall off a trailer and you sustain an injury to your elbow. Let's say you fracture your elbow. But because of the fracture to the elbow, the doctors focus on that, and it's not till a few weeks later that they begin to document that you have this nagging pain in your back that won't go away. And so the insurance company will say, well, we understand that you hurt your elbow, but because the doctor didn't document on the first visit that your back was also hurting, that we're going to deny your back injury. We don't think the back injury occurred on the job. Very commonly, the doctors, especially in the case of a severe injury like a fracture, will fail to document all of the injured body parts because they get tunnel vision and they're focused on one particular aspect of the injury. Or you, as the injured party, may not tell the doctor everything because you fell off a trailer and you fractured your elbow and you're just in pain from head to toe because of how you fell and how you landed. Well, in that situation, the doctor says what hurts. You may be thinking, well, everything hurts. I fell off a trailer and I've got scrapes on my back and I've got scrapes on my leg and I've got a little contusion and everything feels sore and everything hurts. But the main thing I'm focused on is my elbow because my elbow is killing me and I think it's broken. And it really is broken. In those situations, the doctor's not going to usually write down everything that's injured. They're going to focus on the most injured body part, and the insurance company is going to have to sort through what is something that actually relates back to the injury and what isn't. A third type of injury, extent of injury situation we see is what we call a follow-on injury. That is where you have an initial injury. Let's say you fell off the back of a trailer and you fractured your elbow. You went in for surgery. The surgeon may do a good job, but for whatever reason, you end up with an infection. And that infection requires you to be hospitalized. And while you're hospitalized, you have additional complications. Those would be what we call a direct and natural result of the original injury, and they would be covered. You have to go prove that they're covered. Oftentimes the insurance company will dispute that, but those would be things that would be covered as part of the direct and natural result of the injury as a follow-on diagnosis. Another way that you can get those kinds of things is through failure to document. So a doctor may have a discussion with you about the injury, focus in on what is the primary complaint, but omit other diagnoses. Sometimes they'll omit them because the employer didn't mark them on the paperwork that they received to start treating you. So all these things can create what we call an extent of injury issue that needs to be dealt with through a hearing. This is where you would request a benefit review conference, go to a contested case hearing, probably in the interim go see a state-appointed doctor, and in the end you would have a hearing with multiple medical opinions, one from a neutral state-appointed doctor, probably from your doctors as well, perhaps from insurance company doctors that have examined you or reviewed your records. You would offer testimony about how the injury happened, when the follow-on injury came about, or when you became aware that you had another body part that was injured in the accident. And the judge would look at those things, look at the medical records, look at witness statements, review your testimony, as well as the testimony of any other witnesses, including doctors, and the judge would write a decision either ordering benefits or denying benefits for the extent of injury diagnosis in your Texas workers' compensation claim.